invest in capacity building for our forensic experts, conduct training of investigating officers, and invest in our court system. Key provisions of the new criminal law would only produce a positive impact if these investments are made as soon as possible. Let us take the example of the timeline prescribed for the completion of trials and the pronouncement of judgments after the judgment is reserved. The BNSS provides that criminal trials must be completed in 3 years and that a judgment must be pronounced within 45 days of it being reserved. Stipulation is a breath of fresh air for addressing the issue of case pendency as well as the accused in a criminal case. But if the court infrastructure and the prosecution lack material resources to harness technology and conduct an efficient and speedy trial, then the guarantees of the BNSS may run the risk of becoming merely directory and becoming unimplementable. Recently, in fact just this morning, I've addressed a letter to all the Chief Justices of the High Courts, emphasizing that the Bureau for Police Research and Development has prepared a module for training and development for training of all stakeholders, including judges, public prosecutors, and others. All states in the country have their state judicial academies. On the part of the police, we have the Police Training Academy. Now, it is important that we synchronize the training which is taking place in the state judicial academies, as well as the Police Training Academy, particularly the one in Hyderabad, to ensure that we are able to synchronize our efforts and truly reap the benefits of the legislation which Parliament has introduced. Citizen-centric approaches have been adopted for supply of a copy of the first information report to the victim and to inform them about the progress of investigation, including by digital means. Additionally, the BNSS has made a positive development in protecting the fundamental rights of under-trial prisoners. Section 481 prescribes default bail for an accused who has undergone 1/3 of the term of punishment for the offence charged against him. This is a complete and radical alteration from the earlier provision or the earlier prescription under the CRPC. The BNSS prescribes that in cases where the punishment for the offence is 7 years or more, the victim shall be given an opportunity of being heard before the withdrawal of the case by the government. Summary trial has been made mandatory for petty and less serious offences. The magisterial system has also been streamlined. One of the problems of our criminal justice administration is that we treat the serious and the petty almost on the same footing. That has to change, which it has changed under the new laws. But the real challenge is about changing mindsets on our part to adapt to the new system. Bearing in mind the evolving nature of crime and the emergence of new digital crime, it is imperative to boost the infrastructure and capacity of our police forces. Crime in contemporary times reflects the technological advancement of our age. Because of the inertia in the law, unfortunately, and the procedures governing investigation, our ability to hold criminals to account has been affected. Our attention must be focused on improving investigation by allowing for multidisciplinary investigation teams with law enforcement officers and domain experts in the field of cybercrime and pattern recognition. Technology must also be harnessed to improve the capacity of prosecutions and the court to work more efficiently. The prosecution can use technology to streamline paperwork and data to identify similar cases. This will enable the courts to streamline the listing process. The digitization of files and infrastructure for conducting witness examination online must be harnessed to record and produce voluminous material with the swiftness of a tap on the screen. Our laws and their implementation are an ever-evolving area. There is no finality to any law or the manner of its implementation. However, we must be willing to embrace positive changes to meet the needs of our times. I expect that with the implementation of the new criminal laws, we will discover loopholes and areas which need to be addressed. Such debates would be helpful in enhancing the efficiency of our criminal justice administration. The ideological framework at the heart of our analysis must be justice-oriented, with a civil liberty-centric approach which balances the interests of the victim and the accused. The moral advantage of a criminal justice system in a democratic society is that it affords the victim an opportunity to reclaim their agency and confront an accused. It also lies in the fact that all persons, no matter how high or how low, would get full opportunity to defend themselves before a court of law. I hope that the various panel discussions in this conference spark a positive conversation on various aspects of the new criminal laws. These conversations are vital for our collective growth in an evolving legal landscape. As we look to the future, we must learn from our past and take its teachings with us. The new laws will be implemented by existing personnel. Now, that is going to pose a challenge for all of us, because these laws will call for a change in practice, a change in mindsets, new institutional arrangements, the re-engineering of our processes. We will have to strengthen existing structures. Let us not forget that while these new laws have been enacted recently by Parliament, our structures, our institutions, are robust institutions in a democratic framework. So we will have to build on the existing structures which we have and not discard them. And I would particularly like to highlight the importance of the use of e-filing, better litigation management by the use of existing tools such as the National Judicial Data Grid, the adoption of technology to bring knowledge and information to all stakeholders, the digitization of records, building on the interoperable criminal justice system, facilitating the adoption of speech-to-text transcription of evidence and judicial orders. In the Supreme Court of India, we have already started implementing the transcription of speech-to-text in important hearings before the Constitution bench. The E-Committee of the Supreme Court of India, in conjunction with the Department of Justice, has prepared a pilot model of transcription of speech-to-text. Now, this simple innovation will speed the process of recording evidence, of recording judicial orders, and ensuring speed in our process. Finally, I'd like to stress on the use of artificial intelligence. AI will enable us to track progress in criminal trials, right from the stage of the FIR to the conclusion of the trial. We must deploy AI for the purpose of noticing aberrations in the process. When a trial is delayed, when witness testimony is delayed, AI will be able to flag for us red marks on why these delays are taking place, providing decision makers for supervisory control at all levels of the criminal justice administration, creating templates for simple orders and simple pleadings and simple filings. So technology today is replete with a world of opportunity for us. So it is not enough for us to only notice the radically new provisions of these three new legislations. A conference like this is important for us to educate ourselves about the changes which Parliament has brought about. But equally, we must focus on ourselves, because these new laws will be successful if we who are in charge of implementing these laws adapt to them not only in terms of our institutional process, but in terms of our mindset as well. As a very distinguished judge has said, the law is a witness and external deposit of our moral life. Its history is the history of the moral development of our civilization. And therefore, I hope that with this conference, all of you and all of us will be alive to both the challenges, the opportunities, and the duties which are cast upon us as important stakeholders in the implementation of law. I would conclude by thanking the Department of Legal Affairs and the Union Minister for having so graciously invited me for this. I spoke at the CBI annual lecture just the other day. The director of CBI had invited me and I spoke on a similar topic. I think that fueled the invitation to this particular morning's conference. I'm thankful to you for inviting me, and only want to assure all of you that in tandem with all the steps which you will be taking, the judiciary, which I represent as the head of the family, is equally alive to its responsibilities, and we are in the process of discharging our own responsibilities to make this law.